This is Speak Up. I am Sandra Schulte. Welcome back to our show. Today, I'm very thrilled to have Professor Thomas Rosinski with us. Professor Thomas Rosinski is a principal pre-law advisor for all of the Touro University students. He is the current president of the New York Association of Pre-Law Advising and Pedagogy. He was graduated summa cum laude, can't do better than that, from Yale University. He has an MA from Harvard in government and a JD cum laude from Harvard Law School. Before joining Touro, Professor Rosinski practiced law at two large law firms in Manhattan. He was partner at Anderson Kill and Olick. His then partner, Rudolph Giuliani, was elected mayor, and Tom joined him in the New York City government, serving as general counsel to two city agencies and also as commissioner of homeless services in 2001. After that, he taught at the University of Michigan. Then he came to Touro in 2006. And now here he is. And I'm going to ask Professor Rosinski to please talk about something that I think is going to be a major issue. He's going to talk about how Dobbs is establishing a new constitutional right for women. Please.
Well, thank you very much, Sandra. So recently, the Supreme Court in Dobbs versus Jackson Women's Health Organization struck down what had been a constitutional right for 49 years, and that was the right of a woman to have an abortion. In the opinion by Justice Alito, he said that because there is no right to abortion mentioned in the Constitution, any such right would have to be found in the history and tradition of the United States.
Very important, history and tradition.
And in our history and tradition, there was no real discussion of a right to abortion until the 1960s. And while women did have abortions before, that wasn't a matter of right. It was simply because for a long period of time, women could have early term abortions prior to quickening or the movement of the fetus. And so what he said was, since there's no constitutional right, the law in Mississippi merely had to satisfy what's called the rational relationship test.
So in other words, it had to be in the Constitution. It couldn't be custom or someone's done it before.
Well, if there had been some recognition of a right that wasn't mentioned, such as, for example, the court has said you have a right to get married, even though it's not in the Constitution, right? But in this particular case, there was no history of a right to abortion. And so because of that, they said there's no reason why Mississippi can't restrict abortion after the first 15 weeks or so of pregnancy. And he said that the state's interest in doing so was to protect unborn life. However, in doing so, what he essentially said is that women in Mississippi and in many other states that after Dobbs have adopted or resurrected laws banning abortion, that essentially the government now is allowed to regulate and take over the bodies of women who are pregnant. And that implicates another very important clause in our Constitution, and that's called the Just Compensation Clause. It's the last part of the Fifth Amendment, and it says, nor shall private property be taken for public use without just compensation.
Very interesting. Nor shall private property be taken for public use without just compensation. Very important.
Okay, so let me give you an example of how this works.
Go on.
Let's suppose that the FBI believes that your next door neighbor is engaged in some suspicious activity, and it believes it needs to undertake surveillance in order to get a search warrant. Now, it can get an order from a judge, basically forcing you to allow it to use a room in your house for the purposes of surveillance. But that would be taking over your property, and you'd be entitled to compensation for the use of that room, any additional expenses you had, such as higher utilities, and also any loss of business, such as not being able to have clients come into your home. In this particular case, what Mississippi basically says to women after the 15-week period is, we are going to take over your womb. We're going to tell you how you need to live, what rules you need to follow, such as not drinking, not perhaps engaging in strenuous exercise. We're going to expect you to have regular prenatal care. And we are most importantly going to tell you that you must carry this baby to term. Now, this imposes a lot of costs on women. Right? And it's not just the fact that there might be increased money for food or for doctor's appointments or for maternity clothes. Carrying a fetus to term increases the risk of death by about 14 times. That's what the dissent in the Dobbs case said. It increases the risk that a woman faces. And so what we have here is the government is imposing additional costs on women for a public purpose, which basically is creating new citizens. And the Supreme Court said, that's fine. We get new citizens because of the state's interest in life. So the question is, Sandra, is this a taking? And is the mother entitled to compensation under the Constitution? So let's look at three things. First of all, is it a taking? Very clearly, she's not able to do what she wanted to do. She is required to change her life, often dramatically. So it's certainly taking her body for a particular purpose. Secondly, is it for a public purpose? Well, the court has said yes. This is a public purpose, protecting unborn life and future citizens. And so the question is, what is just compensation?
That's a big question.
It's a big question, but it's one the courts have not had difficulty figuring out, because essentially what they've said is, what are the economic costs that a person has from carrying a fetus to term? And those are the cost of medical care, the cost of additional food, of clothing, of perhaps time taken off from work, and the actual cost of giving birth. And so basically, under well-established Supreme Court jurisprudence that goes back well over 100 years, it would seem that the consequence of allowing states to bar abortion is that it creates a right for all pregnant women to obtain compensation for the costs of pregnancy.
Sounds like rent a room to me.
Well, in a sense, that's what it is, right?
Yes.
And see, my concern is that women's rights advocates will spend a lot of time trying to fight this decision. But politically, we're not going to overturn Dobbs in a short period of time. Right. The Supreme Court's not going to change. There aren't the votes to put new people on the Supreme Court. We're stuck with the Dobbs decision.
So they have to decide what is doable.
So the point is that rather than lament and say, oh, this is a terrible decision, it set back the cause of women, why not look at it and say, well, maybe it actually can be used to advance the cause of women? Because when you think about it, women provide us, through caring for fetuses to the point of birth, a service that men can't provide. And one of the reasons the Supreme Court has recognized as the purpose of the Just Compensation Clause was in a case called United States versus Armstrong, where it said where certain people have to bear more of the cost of something that benefits everyone, they should receive compensation. So why shouldn't all pregnant women receive compensation from the moment at which they can no longer reverse their pregnancy up until the moment that they give birth? Now, I want to raise another concern I have about this.
Go on.
Which is that right now, states that are passing restrictive abortion laws are not punishing women who have abortions. But what happens when they start doing this? Inevitably, someone's going to say, well, isn't it really the mother that instigates the decision to have an abortion? And I suspect that in some states, you're going to see penalties, criminal penalties, that are going to be placed on women who have abortions.
Such as prison.
Well, that would be the obvious one, I think, beyond any sort of fine. And what happens when those women say, I don't want to go to prison just because I had an abortion after I was raped by my grandfather. I need sanctuary. And I'm going to go to a state where abortion is legal. And then the state that they're from says, oh, you violated the laws of our state. We want you back because we want to try you for a crime. What's happening if this were to occur would be really a replication of what happened before the Civil War with regards to the Fugitive Slave Act, where this country was torn apart by a law that said states in the North had to return slaves to their masters, even though those states believed that slavery was immoral and it didn't exist under the laws of the states. So what's going to happen now? Is New York going to say, oh, well, this is a federal law, we need, if there is a law requiring this? I mean, we have the extradition clause in the Constitution that says if one state wants someone returned to face criminal charges, the state in which they live should return them. But what if states start saying, we're going to abide by this? We're not going to obey the extradition clause. We don't believe that abortion should be a crime. Are we now going to face one of the greatest threats to our union? Probably the greatest threat that we have seen since the Civil War. Is this going to lead to a situation where essentially we have states disrespecting each other's laws?
It's a very good question.
It's something that concerns me, and it may not be happening right away, but
happen.
looking down the road, what's going to stop it? If a state can control a woman's reproductive organs, why can't it impose criminal penalties? There's no constitutional reason why it can't do that. And that's another thing that I'm concerned about. There's a lot to think about, but in the short run, I think women should recognize that Dobbs could be a real boon. It could really give them an opportunity to fight for equalization of maternal rights and give them a constitutional basis for saying that every mother, rich or poor, is entitled to compensation from the state for all the costs of producing new citizens.
And the states will have to look to their budgets.
Well, they'll look to other taxpayers, and those
Yes.
taxpayers may say, well, maybe we don't want to pay all these costs. Maybe we're being too restrictive in saying the right to abortion ends at 6 weeks. Maybe they won't. But the point is, it'll force them to consider the cost, because any time that you take over somebody's body, you need to pay the cost. That seems to be the whole basis of our just compensation clause.
But however, in a campaign to make to criminalize it, the cost will not be mentioned that much. The idea that it is a criminal act, that abortion is terrible, will be the high point. They won't really focus on how much it's going to cost the individual taxpayer, I'm afraid.
Well, I think that we don't really know what the focus is going to be on that. We don't know where the first state is that's going to try to put criminal penalties on women. But this is just something to think about down the road as causing a problem. I think that right now, the really big issues have to deal with to what extent will states that allow private prosecutions, and for example, in Texas, Texas allows private individuals to sue anyone that's involved in procuring an abortion. And so let's suppose that a woman travels to a state where abortion is legal on the basis of information that's provided to her by someone in Texas. Well, that person could be sued. The Uber driver that took her to the airport, I mean, theoretically, the pilot of the plane, right? Someone that sold her a ticket. All these people could be sued under some of these laws.
And they will be sued.
And we don't really know because people are trying to avoid this type of lawsuit, but essentially everybody involved in the process can do this. And essentially what it does is it creates a culture of vigilantism, right? Largely, we recognize that the police, the state troopers, law enforcement authorities, they're the ones that should be involved in enforcing the criminal law. By and large, we don't really agree with the concept of citizens' arrests because they too often lead to people being abused by individuals who don't know the proper way to treat people who have been caught and are suspected of a crime.
I don't care.
So it's not something we do. Maybe we did it in the 19th century when there was no police force and we relied on something called a posse comitatus, when if a crime was committed in a community, that there would be a hue and cry and all the men of a certain age would get together and go hunt down the perpetrator.
Sounds like communism to me, the communist system.
Well, you know what's interesting is this is what China does. China empowers private individuals to punish or initiate prosecutions of individuals. So,
Yes.
for example, in this country, it's almost impossible to be fined for littering unless you do it right in front of a policeman and he's got nothing better to do. But in China, private individuals can turn people in for littering. And then they get hauled into court, they get fined, the private individual turned them in, gets a portion of that fine. They essentially enlist private individuals as servants of the state for the purpose of keeping everyone in line.
Yes.
And that's one of the disturbing trends I see in allowing this type of law to go forward. You know, the Supreme Court didn't stop it. It had an opportunity to do so. It didn't do that. Now there is another challenge to this that's going on in Texas, to this particular law. But it seems to be a very disturbing trend that we're going to say to people, okay, you can get involved in people's lives, you can engage in prosecution, you can make money from this. That essentially means that everybody becomes a suspect of everyone, right?
That's right.
Turn citizens against each other.
And you can pretend that someone did something because you don't like them.
Well, there's always the threat of malicious prosecution, except it's multiplied by all the people that can prosecute them, right? We don't have a big problem, I don't think, in this country with the police just singling out individuals they don't like for being prosecuted.
Not the
But
police,
what about
but
a neighbor who
That's
doesn't
right.
like another neighbor? They play their music too loud. Oh, I bet they had an abortion.
Mm-hmm. Yeah.
So this is something else that, it's another concern that I have for this that comes up. But we are facing a lot of changes in this country. And I think that the Dobbs decision is one of the most important decisions the Supreme Court has made in the last 50 years, and one of the most far-reaching. Now, some people have said that Dobbs is the first time the Supreme Court has ever taken away a constitutional right. They're actually not right about that. There was another right that the Supreme Court created in the 1890s. It was called the right to contract. And it basically said that individuals should be free to contract with other individuals or companies, irrespective of restrictions like minimum hours and maximum hours and minimum wage and health and safety precautions. And so they struck down a lot of laws that limited how much work individuals could do. But then the Supreme Court in 1937 said, no, Congress has a legitimate role in protecting individuals from having to work too long or in keeping wages high enough that people have enough money to live on. So this right existed basically for about 40 years, from 1897 to 1937. It was largely discredited. The court has never suggested really bringing it back. But in taking away this particular right, though, what I think you need to wonder is, will there be other decisions that create threats to this? In his concurrence, Justice Clarence Thomas talked about the right to contraception. There's also no constitutional right to contraception. This is a right the Supreme Court created in 1965 in a case called Griswold versus Connecticut.
And taking away the right to contraception conception might be based upon trying to create new citizens.
Well, if there is no right to contraception, and historically it's difficult to show that that was ever a right under the test announced by the Supreme Court in Dobbs, the Supreme Court might say Griswold was also wrongfully decided.
And the test is?
The test is whether it accords with the history and tradition of the American people. And we know that people have always tried to limit their family, but once again, it was not something that was seen as a right until sometime in the 20th century.
So in other words, even though there was nothing in law in 1776, and people did have abortions.
Or people engaged in other activities to prevent them from having more children, right? That's essentially what we're talking about here, family planning, right?
Yes.
There are various ways that you can do this that don't involve abortion.
Timing, for
Right.
instance.
So, the threat, I think, is if you use the type of reasoning that the Supreme Court did in Dobbs, that you might now see a challenge to laws that allow individuals to obtain contraceptives. You're already seeing some concern about that with regards to what's called Plan B, because Plan B essentially occurs to prevent the implantation, right, of the cells in the uterus. Essentially, you can argue that in a state that bars abortion as of when the ovum and sperm unite, right? Essentially, that could be seen as a means of abortion. And you might have Plan B being barred from some pharmacies in states like Oklahoma. But
right.
You could have this become a much bigger thing in states if they say, we're going to push this to the level of contraception.
So Blackstone's commentaries in 1774 didn't address this.
Well, this gets back to what we talked about in the beginning, because Blackstone essentially drew a distinction between abortion prior to quickening and abortion after quickening. And after quickening, it said that it is some type of serious misdemeanor. In other words, it's a crime. But it couldn't really be a crime prior to quickening because there was no reliable way to tell whether someone was pregnant. And since in our, judicial system, there has to be guilt beyond a reasonable doubt, there's no way to know whether someone was actually pregnant. So there'd be no way to really regulate it. And so it makes perfect sense that there was no restriction on it. But no one went around saying, I've got a right to have an abortion because I can't feel this potential life within me quickening.
Yes, I wonder what if the states will consider this to be a misdemeanor or a manslaughter.
Well, the point is, if it was criminal, there's clearly no right to do it.
Yes.
But the court is basically saying it doesn't matter whether it's criminal or not, it's whether it's conceived of as a right. And that's the concern about contraceptives as well as abortion. If there's no right and no discourse about it, no acceptance of it as a right, what's to prevent the court from overturning Griswold and saying if a state wants to ban all contraception, it can do that? And then we have even more problems because there, we at least have people attempting to be responsible about sex, right? You can argue that people that have unprotected sex and don't take precautions against pregnancy sort of essentially accept that sort of risk. But if they can't even mitigate that sort of risk, are we then going to say, well, everyone must abstain from sex? Perhaps there might be some religions that want us to do that, but I think that would be forcing religions of a minority of Americans or their views on everyone.
And also condoms prevent spreading of disease, aside from just creating a child.
Exactly. Another concern.
Would you repeat the wording of the Due Process Clause that gives the woman a new right, the right to compensation?
Well, it's the Just Compensation Clause, you mean, okay? Right? And it's the end of the Fifth Amendment. It says, nor shall private property be taken for public use without just compensation. Right? And I talked about the three things. You've got to show private property, you've got to show public use, you've got to show, then you have the right to just compensation.
Is there any other state purpose besides making a citizen that they might?
Well, there were a number of things that were listed, largely talking about the protection of their health as well as their well-being. And certainly those are things that that states have historically done. I mean, the purpose of government is to provide for the welfare of the people. But one of the other concerns about this decision is what about women's mental health? In other words, let's take someone who has a very traumatic pregnancy. Maybe it was a result of incest or rape. Maybe it was simply that a woman is pregnant as a result of interaction with her husband, but her husband has turned out to be very abusive and she doesn't want to be with him anymore, but is yet forced to carry his child. Those can all be situations for significant psychological trauma. But in states that bar abortion, those don't appear to be adequate reasons for abortion. The question is, how significant would the psychological trauma to be to really threaten a woman's life? And many people would say, well, that's a really high barrier. And so a woman that is absolutely traumatized by the fact that she's 14 years old and she's pregnant because of some stranger that attacked her one night, that doesn't seem to be enough. And so we might very well have women that face psychological problems their entire lives because they're forced to go through and bear a child that they never had any indication
and didn't want.
Yes.
And therefore will not treat the child properly necessarily.
Well, irrespective of that, maybe they do, right? The maternal instinct is very powerful. Even women that are raped do care for their children in most cases. So it's not so much that, it's what's the psychological cost every day of trying to help a child that was created as a result of a rape? I don't know. I can't ever evaluate that because I can't ever have a child. But I'd be willing to bet that there are women out there that have gone through this and they're going to say, it was really, really tough. It set me back months or years in my life.
But the problem is you have to have a preponderance of them to raise their voices and maybe be heard, maybe be heard.
Well, you know, there are more women than men in this country. And there are more female voters. More women vote than men as a percentage. So this is their chance to stand up. And this is one of the great hopes for the Democrats, is that this will galvanize voters in November to vote for candidates that want to make changes. But we don't know if that's going to happen. Gerrymandering has made it very easy for Republicans to maintain holds on state legislatures and even on the House of Representatives. Right now, there's a real concern that even if this causes a shift in how people vote, that the Republicans might take one or both houses of Congress. So we need to focus on trying to establish a legal constitutional right, and that's something that could be done through the Just Compensation Clause. And that's why I think that's really where the focus should be.
Folks, please listen to Professor Rescind say that again.
That's where people should be focusing on. They should be focusing on using the Just Compensation Clause to create a right for all mothers to receive adequate state funding to bring their child to birth.
Professor Rescind, I want to thank you so much for having come on our show. You couldn't have been more informative. I want to thank you for all the women out there who are going to be affected by this abortion issue.
Well, thank you very much for listening to me and having me on today.
This is Speak Up with Sandra Schulte. Thank you so much for coming back to our show. Have a wonderful, wonderful rest of the day. Goodbye.